All right, on to our next speaker. I'm very proud to introduce Patrick McGahan, who's a partner of Scott+Scott Attorneys at Law, LLP's Connecticut and London offices, and works closely with other members of the firm's antitrust and competition practice in counseling corporate and institutional clients, evaluating potential claims, and developing strategies to recover losses caused by anti-competitive conduct. He has a strong focus on consolidation and the impact of anti-competitive conduct in agricultural industries. He is presently co-lead counsel in the INRI cattle and beef antitrust litigation, acting for RCAF USA, the National Farmers Union, and the cattle producer plaintiffs. McGahan has also acted for clients in a variety of securities litigation, arbitrations, both investment treaty and commercial, and pieces of general commercial litigation. And so since April of 2019, I've gotten to know Pat, and we're excited to hear an update from him. So let's welcome him. Thank you.
Too kind. I was here to talk about my favorite thing, which is why America should import more Australian beef, but Eric told me that that would be a bad idea, so I'm going to stick to my day job and talk about the litigation. It's always a pleasure to come out here. I think this is a beautiful country, and it's great to visit with all of you and talk a little bit about what we're doing and the great work that RCAF and the other plaintiffs are doing for this litigation. Also like to say hello to all the defendants' attorneys who dial in to hear me speak each year, hoping that I say something stupid that they can take to the court. This may be your lucky year. You never know. We're going to talk briefly about the litigation. We'll talk briefly about the JBS settlement, what's happening with the government investigations. If there's time, touch on a couple of other pieces of litigation you might all be interested in, and then take some questions. I am going to promise to keep to my allotted time. I see there is a bar crawl later, which will be more interesting than hear me talk. All right, so what have we been doing in this litigation in the past year? It's a big case. It's been running since 2019. Why, you may ask? It is one of the largest MDLs in the country. An MDL is an abbreviation for what's called a multi-district litigation. It's where a variety of cases are consolidated before one court, all run together. So that court here is the District Court of Minnesota before Judge Thunheim. So not only does he have the fat cattle sellers claim, he has a claim on behalf of feeder cattle producers, he has a claim on behalf of 3 classes of beef producers, and about 40 large beef purchasers like McDonald's, Kroger's, etc. All of which to say is there's a lot of discovery and it takes time. In the past year, about 80 defendant employees were deposed. Myself and my colleagues took about 30 of those. There was about 20 or 30 depositions of non-parties. This would include things from feedlot owners to marketers to various analysts in the beef industry. And a big shout out to all of the representatives who are acting on behalf of the fat cattle, like Eric, Chuck, Jim, Rick, and Bill, all of whom had their own deposition taken. In the case of Chuck and Bill, they had to sit twice. The defendants liked them so much. So there's a lot of work going there. Discovery is now closed. We have finished briefing class certification. Class certification is the motion where we ask the court to treat this case on a class-wide basis, i.e. Rick, Eric, Jim, etc. are not just suing for their own losses, but the loss of everyone who sold fat cattle to the defendants. That has become a very large battleground in class litigation. It used to be that the court would easily certify a class. Now it is very difficult, and defendants are trying to limit it just to the named plaintiffs and not everyone who sold fat cattle. We are hoping to get a hearing from the court soon in the summer, so we'd hope to have a decision by the fall. The next step, assuming we go through that, is the defendants will move for summary judgment, and they will try to argue that there's not sufficient facts that a reasonable jury could find that there was an agreement amongst the 4 defendants to conspire. We will of course argue that there is sufficient evidence, and that will determine whether or not the case goes to a trial. We don't yet have a trial date. We've asked the court to set one in late 2026. The defendants have asked for one in mid to late 2027. The court has not yet decided. That is exactly what is next. So as I said, there's a parallel suit so we represent the folks who sold finished fat cattle to the packer. There is also a parallel suit on behalf of those who sold feeder cattle to somebody who put them into a feedlot. That suit had originally started as anyone who'd sold a calf through to a feeder cattle. The court trimmed that just to people who sold a feeder cattle between 700 and 899 pounds to be put directly into a feedlot and sold to a packer. The reasons for why it got trimmed are very boring and technocratic, but they come down to a doctrine called antitrust standing. But that case continues. They have likewise moved for class certification, and at the same time the court hears our motion for class certification, they will hear theirs. And so that's more of a watch this space. As some of you may have seen in the press or in the news, we reached a settlement with one of the defendants, JBS, at the beginning of the year. That settlement, because it's a class settlement, it goes through a court approval process. So there's 2 steps to simplify. First, we move the court for what's called preliminary approval. And that's the court eyeballing and saying, yes, this is a settlement that I can envisage is of the type that I would find ultimately to be fair and reasonable. Once we get that nod, we send notice of the settlement to all the class members. They are then given an opportunity to opt in, to share in the proceeds, to opt out should they wish, and to give comment to the court, to technical word is to object. The court then in August is going to decide finally whether or not it will approve the settlement. And again, the standard there is this a fair and reasonable settlement? The key deadlines for folks who sold fat cattle to have in their mind are, firstly, the deadline to submit a claim to share in that settlement is September 15th. You can do that via a hard copy, or you can submit it online, and I'll share in a little bit the website that sets that out. The deadline to opt out or object is July 7th, 2025. You might ask, why might you want to do that? Facetiously, I would say you must hate free money. More seriously, people might want to opt out if they decide that they want to sue JBS themselves, because if you don't opt out, you are bound by the release that the settlement has to JBS. Object, people sometimes object if they think that there's something wrong with the settlement. We don't expect that to be the case here, but it happens. And I'll talk a little bit about the claims process in a moment. So, the settlement class, the people who the settlement covers, is anyone who sold fat cattle to one of the big 4 packers from June 1st, 2015 to February 29th, 2020. You do not have had to have sold fat cattle to JBS. If you sold fat cattle to Tyson in that period, you are in the class. If you sold it to National Beef, you are in the class. One of the common questions we get is, do I have to have sold fat cattle with JBS to participate? No, and the reason for that is under antitrust law, JBS is, as a conspirator, alleged conspirator, it's jointly and severally liable for the loss on the other defendants' cattle purchases. So when it settles, it's not just settling for the loss on the cattle it bought, but for the cattle the other folks bought. The next question we often get is, if I submit a claim, will JBS or the other packers know? And the answer to that is no. So first of all, the claim is not a public document. You are submitting basically a 2 or 3 page document with evidence of what cattle you sold, and I'll talk about it in a moment, and certain live cattle futures trades. That goes to the claims administrator. The claims administrator is a court-appointed company whose sole job is to administer class settlements like this. And the claim form is just for them to assess how many cattle did you sell, for us to be able to verify that and to work out what portion of the settlement you should be entitled to. It is not shared with the other defendants. It is not public. The only thing that would make your participation in this process public is if you opted out of the settlement. That is something that JBS would be told about. If you object, that's public because you're asking the court to come to the final approval hearing and make an objection. But merely submitting a claim, not public, you're not asserting that you agree that the lawsuit is right, that you think the packers are evil. You're just saying, I sold fat cattle in this time and I would like a share of the money. The next question is, if I go through the bother of submitting a claim for the JBS settlement, will I automatically be included in the distribution for a subsequent settlement if one occurs, or if you guys win at trial and there's more money to be handed out? And the short answer to that is yes. We haven't decided the exact mechanism by which the people who opt into the JBS settlement now will automatically be involved in any future distribution. But the short answer is we're going to make it very easy for those who submit a claim now just to say, yes, I would still like to be included, and yes, I would like you to use the information I previously gave you. The final question we often get is, you asked for a lot of details about the cattle I sold to the packers. 2015 was a long time ago. I don't have perfect records. Can I still submit a claim? Absolutely. Do your best to gather the information you have about your cattle sales. We will do our best to verify what they were and go ahead. Don't not submit a claim just because you can't complete all the information about what cattle you sold. Maybe you don't know the total weight, or you don't know the final price, or to which plant that they were delivered. But we're in the interest of trying to uphold claims. We ask for those details because, unfortunately, what happens in nearly all class litigations where there's a significant settlement is that there are some unscrupulous people out there who will submit bogus claims, who didn't sell fat cattle or didn't buy the affected product in another case. And so what we have is a process with the claims administrator where we try weed out those fraudulent claims to ensure that only those who actually sold the cattle share in the money. Where can I find more information? There is a settlement website which has an FAQ section. It has the key documents. That is where you can submit a claim online if you don't want to submit it in hard copy. The claims administrator, they can be contacted at that phone number. Alternatively, if you go to the cattleantitrustsettlement.com, go to the contact section, you can find their contact details. I think there's email, there might be a chat, there's definitely a phone number. If they cannot answer your question, they will reach out to us and one of the attorneys will reach out to you. Government investigations. Folks may remember that the DOJ, the USDA, and various state AGs started investigations in 2020, some off the back of the Holcomb fire, some off the back of COVID, and are those still going on? To the best of our knowledge, they continue. And the reason we think that they continue is that typically, if they close those investigations, they will give the defendants what's called a no action letter, which is basically a letter saying, hey, we're closing the investigation down. Typically, when that occurs, in our cases, the defendants then rush to us and tell us that the government has dropped their claim and so should we. That has not happened yet. So I surmise from that these investigations continue. Beyond that, I can't tell you much about what is happening. One suspects that with the change of administration, at least at the DOJ, there's probably some filtering in terms of which cases to prioritize, to what extent. So we don't yet have a good read of that either way. Other litigation. So there is still antitrust litigation going on in relation to pork, broiler chickens, turkey, and tractor equipment. The most relevant for you good folk to think about or to know about is the pork case. It has a similar pact pattern, some of the same defendants, but more relevantly, it's being heard before the same judge that has our case, Judge Thunheim. And the sort of positive news since we last spoke is that Judge Thunheim certified the classes in that case, and he also largely denied summary judgment that the defendants brought there. So that case looks like it's heading to trial this year. The defendants have brought a last-ditch motion to disqualify the judge in that case. Principally, if you ask me, because they don't like much that he ruled against them. They say it's different. So again, we'll see what he does there. My bet would be that he denies that, but we'll see. And so that's some positive, headwinds for us. Promised I'd keep you on time, heading to the door for beer. But if you have questions, I'm happy to answer them. If you don't want to ask me now, I'm happy to be approached on the sidelines. I'm around for the rest of the day. But thanks so much for listening and hearing me out.
Say, I got a question on how can they be anonymous? How do you verify that somebody sold fat cattle? I mean, if I turn it in and say, well, I don't want JBS to find out that I'm part of this deal, but I sold 10 loads of fat cattle to them, what verification? How can you verify that without them ever knowing about it?
Great question. So as a part of the litigation, we received from the defendants records of all the fat cattle they purchased. So we have a record of all the cattle that JBS purchased during the relevant period. Now, there's a lot of you might know, a lot of folks finish cattle at custom feed yards, or maybe they get marketed through a third-party marketer, and sometimes those documents will say, well, it was bought from feed yard X, but really that pen of cattle was owned by Joe Smith. So we can get the evidence that if you submitted, sir, you would show, maybe you would attach closeout reports or some other report from the feed yard showing you sold those pens. We'd go, yep, that looks legitimate. We would check whether or not, around that time, cattle were sold to JBS from that feed yard, and that would sort of pass the smell test. So we don't have to go to JBS to be like, did you buy cattle from Joe Smith? So basically, from the discovery that's produced in the case, with the records we're asking folks to submit, which is going to be things like closeout reports or other reports from their cattle marketer or whatever other records they kept of the fat cattle they sold, we're able to sort of make that determination without going back to JBS or to Tyson or to whoever and be like, oh, did you buy cattle from Joe Smith? And I should say on that too, like the defendants aren't, and this is universally true in all my cases, the defendants don't, once there's a settlement, they really hope that there is a large take-up. They want the settlement to be successful and approved and participated, because what they want is to buy peace. They don't want a lot of people, not submitting complaints or objecting, because that's not what they're hoping to do. They're hoping to get to the end. They also don't really care, once that money is gone off their balance sheet, they don't really care to whom it goes to. So they don't have a vested interest in sort of sticking their nose into it. So aside from the fact that we wouldn't give them that information, they're just not that interested.
Sir, I'll buy you a beer for an opinion here, but
That's dangerous.
Yeah, First of all, though, thank you for your good work here and for the plaintiffs that went through with this. Thanks a lot. I wish you would have included us cow-calf guys, though, but, okay, here's my question. A $10 billion payment just came out from the FSA offices or the USDA called the ECAP. I call it the kneecap payment. In your opinion, do you think the cattle industry could sue the USDA for giving the corn and bean farmers this free money, which puts us in a competitive disadvantage trying to compete for cattle ground? Is that enough standing to try to go after the USDA?
So it may take you a beer, but I'm probably going to have to pass. 2 reasons. I'm not familiar with that policy. The second, the government's pretty hard to sue, but the short answer is I don't know. But, you know, happy to look at it more, but I don't know sitting here today. But yeah, suing the government for those type of policy choices is always very difficult. And I should say I'm a simple antitrust attorney. The main law in my world is don't fix prices. It's pretty easy to understand. The regulatory stuff that the professor spoke to a moment ago starts to get a little above my pay grade. So sorry, that's not that great of an answer.
Thank you for the presentation. This isn't settled yet. In other words, it could still go to court, right?
Yes. So even in the world in which the court finally approves our settlement with JBS in August, our claim continues against the 3 remaining defendants, National Beef, Tyson, and Cargill. So yes, there's absolutely the case that this goes to trial.
So the 85 million is just against JBS.
Exactly.
So let's follow the monies. So the lawyers get a third of that, right?
The motion to the court is for the attorneys to ask for a third. The court has to approve that.
Okay. And then there's expenses. And let's say there's 50 million left. How many cattle were sold between 2015 and what is the ending date? 23?
Beginning of 2020. So
how many cattle are in that?
So this is where we're going to have to pass a little bit because some of that's confidential under the relevant orders, but you know it's tens of millions are in the settlement.
So if a third of them claim, that'd be 3 billion. So you got to divide 3 billion into 30 or 40 million dollars.
No, sir. There's tens of millions of cattle sold in that period, not billions. And so the way that the settlement funds are distributed is that so many people will submit claim, and we don't try to estimate what their loss was. If 1,000 head are submitted, we divvy up the amount available for distribution amongst those 1,000 head equally. So what folks get will vary depending on how many people submit a claim. Traditionally in class settlements, 20-25% of folks will submit claims in the class. But I can't sit here today, and I don't know yet how many will submit here. Yeah.
Ronnie Rogers from Cedarville, Kansas. We are cow-calf and backgrounders, and we feed some fat cattle. IRS requires us to keep those records back, 7 years I'm not sure. But anyway, if we don't happen to have those, if we go to the feedlot, some of the feedlots are already starting to let us know that they're working on records for us. But one feedlot that I know of has changed hands, and they said they shredded their records when they changed hands. So we're not sure what direction to go.
It's a great question. So when you look at the claim form for the fat cattle piece, there's 2 options. You can submit a documented claim where you fill out a table and say for each pen This was how many head, what price, to which packer, what weight, etc. And you'll submit with that, your closeout report or whatever other piece of evidence you have. If you do not have that for any of your cattle, and this would be a great reason why, 2015 is a long time ago, there's an option to submit an estimate, which is in the next section, it will say, in 2015, I believe I sold approximately 5,000 head. I would have sold them from these 2 feed yards. I would have sold them to these packers. And then we will do our best to work out that that's a good claim. As I said, we're in the interest of upholding it. And if somebody generally has pretty good records for most of their cattle, but there's some that they don't, we're going to work with that person to try make that claim good. So the short answer is, just because you don't have records, don't not submit. There is an avenue to estimate, and then we and the claims administrator will work with you to try get to the bottom of that. And the gentleman makes a very good point. Overwhelmingly, the commercial yards or the cattle marketing associations that we have talked to are happy to help their customers gather records. So if you don't have a record, pick up the phone to the feed yards you used or to the Cattle Marketing Association and ask if they did. And they of course don't have to, but for the most part, the folks that we've talked to have been keen to help their customers. Obviously, they view it as a bit of a value add to help their customers participate. So, and like my mum always said, you can only ask and they can only say no. So, pick up the phone. Guys, thanks so much for listening. And I would just say a huge thank you to all the class representatives. As the gentleman said before, they've done amazing work. A lot of time spent, dealing with the defendants' very onerous discovery demands, talking to the attorneys, reviewing documents to be approved. Each of them have spent probably hundreds of hours working on this case, and it's not a light thing, and there's still more work to be done. So, I just encourage everyone to, go up to them, give them a slap on the back. It's really a community service on their behalf for the industry, and I would, can't thank them enough for doing so. So, cheers.